We are in the chapter of center-state relations, and we have already seen the legislative relations. And the main thing in Indian constitution is the center is always powerful, or other states in extraordinary circumstances, the states become subordinate to the center. That is a problem, and that is what exactly we are discussing in the center-state relations, where all the states are becoming subordinate to the center. So, in this particular video, I would like to talk about the administrative relations. So, the chapter heading is administrative relations. In this also, the main focus is where all the states are subordinate to the center, because the constitution makers have formulated a very strong center. And what are the constitutional provisions, and what are the other areas where conflict is there relating to this administrative autonomy of the states, or where all the center can overpower, or other centers whims and fancies or centers will be prevailing. That is what we are discussing in the administrative relations. So, the success and strength of a federal polity depends upon this cooperation and coordination. What is expected is cooperation and coordination between the center and the states. But many a times that may not be happening. The center has more power. In fact, if you look at in a federal system, one of the complicated issue is related to this administrative relations. Of course, financial relation is equally complicated, but these administrative issues are equally complicated in many cases. The framers of the constitution decided to include detailed provisions to avoid clashes. So, that is why the administrative relations are clearly mentioned in the constitution. The framers, the constitution makers wanted this to be properly mentioned, so that the conflict can be avoided. And in US, for example, the federal and the state administration runs parallel, and there is no direct or indirect power over each other. In US constitution, the central administration or the federal administration as well as the state's administration are running parallel. There is no overlapping, but in Indian scenario that is not the case. There is overlapping, and we know that the central administration prevails over the state administration. That is the Indian scenario. Now, coming to the constitutional provisions. So, let me talk about the constitutional provisions where the states are subordinate to the center. That is what we are talking in the administrative relations. The constitutional provisions where the states are subordinate to the center in administrative relation or in administrative matters. So, where all in the constitution the states are subordinate to the center in administrative matters. First of all, Article 256 very clearly mentioned, Article 256. It clearly says the executive power of the state should be so exercised as to ensure compliance with the laws of the Union Parliament. So, executive power of the states, should not impinge or should not affect or should not violate. The executive power of the state should not violate the laws of the Union Parliament, should not violate the laws passed by the Parliament. So, the executive power of the state should not violate the laws passed by the Union Parliament. So, that means the laws of the Union Parliament are above the administrative power or rather the executive power of the state, very clearly mentioned in Article 256. Similarly, in Article 257, here the executive power of the state should not violate or impede or prejudice the executive power of the union. the executive power of the state, should not violate, should not impede, or violate the executive power of the union. So it's very clear. The executive power of the union is above the executive power of the state. Article 257. Similarly, if the states does not comply with the directives of the center, if the center is giving any directive to the states, and if the states are not following those directives, the center can invoke Article 356. They can dismiss a state government. So third point is, if states fail to comply, with the directives of the center, if the states fail to comply with the directives of the center, then center can even invoke Article 356. That means dismiss the state government. So again, the states are subordinate to the center when it comes to the administrative relation. Then at point number 4, I would like to say here is, according to Article 258(2), the Parliament can use the state machinery for the enforcement of the union law. Parliament can use the state machinery for implementing the union law. To implement the union law, Parliament can use the state machinery. So again, who is deciding? The center is deciding. Then another point is, administrative autonomy also includes the power to appoint the bureaucrats. Please note, a fifth point I would like to add here is, when you talk about administrative autonomy, the state have their own state administration, center has their own that means state government employees are there, central government employees are there. So the power to appoint, power to punish, power to dismiss an employee is part of the administrative autonomy, Okay. The power to appoint or punish or dismiss an employee is part of the administrative autonomy. See, state government employees, the state government through its mechanism, maybe a state public service commission, they will recruit, they will appoint, the governor will be appointing a state government employee, and the governor can punish, the governor can dismiss. All these powers are but when it comes to the All India Service personnel, All India Service, say IAS, IPS or Indian Forest Service, they are appointed by the center, but work under the state for national integration. But what is happening here, and they cannot be punished by the governor, they cannot be dismissed by the governor, at the maximum they can be suspended, that's all. No harsh punishment can be given by the governor. So the administrative autonomy is violated when it comes to the All India Service personnel. Please remember what I am talking. The administrative autonomy we are talking, or administrative relations between the center and the states. We are again trying to prove that in many cases the state's autonomy is violated, or states are subordinate to the center. So when it comes to All India Service personnel, IAS, IPS, Indian Forest Service, they are appointed by the center but work under the state government. And these All India Service personnel cannot be punished by the state government. They cannot be given at the best they can only be suspended by the state government. So the administrative autonomy of the states are compromised when it comes to this appointment of All India Service personnel. So the power to appoint, punish and dismiss an employee, as far as the All India Service personnel are concerned, it is not there with the state governments. So So, that is a violation of the administrative autonomy of the states. Then another point is as far as the deployment of military and paramilitary force in a state, military and paramilitary in a state. So, if a deployment is required, if the law and order situation has gone wrong, see, law and order is a state subject, but when it comes to help them, to help the state governments in law and order situation, if military or paramilitary forces are required in a state, center will decide everything. Center will decide, the states have no role, and center can even deploy paramilitary forces even without the wish, or rather without the state government demanding. The center can deploy military or paramilitary in a state, again violating the state's autonomy when it comes to administration of the state. So, deployment of military and paramilitary forces in a state, center can decide, states cannot decide. A seventh point is Article 257(2). It says the executive power of the union shall extend to give directions as far as means of communication is concerned. The executive power of the union can be extended. So, the executive power of the center shall be extended to give directions, can give directions. Executive power of the center can give directions to the states as far as the matters related to communication is concerned. See, the communication facility, communication is very important, and the center can extend direction to the states as far as communications is concerned. Communications is concerned. So, the states have no choice, and state will have to follow the direction. If the states fail to follow the direction, center can even take the extreme step, that is dismissal of the state government. Article 356 can be there. So, Article 257(2) says the executive power of the union shall extend to give direction to the states as far as the communication aspects are concerned. The maintenance, the construction of various communication facilities in India, the center can give direction to the states, and it is needless to say, if these directions are not followed, what can happen? They can even be dismissed. Similarly, point number 8, as far as railways are concerned, Article 257(3). Article 257(3), same thing. The executive power of the union shall extend to give direction to the states as far as the protection of the railways within the state. For protection of the railways within the state, the center can give directions, and these directions are binding. So, these are some of these, Article 257, these directions are non-justiciable directives. We can say this Article 257 directives are, we can say, non-justiciable directives which are binding on the states, which are binding on the states. These we call it as the non-justiciable directives which are binding on the states. You cannot go to the court. If a directive is given as far as communication is concerned, as far as railways are concerned, we have no choice. The states will have to follow it. That is why it is called non-justiciable directive. Non-justiciable directives means you may not be able to go to the court. Court will not give any review. Why this directive is given and all, you may not be able to go to the, and it is binding on the state. The states have no choice. They have to follow it. Similarly, in case of any interstate water dispute, point number 9, as far as the administrative relation is concerned, as far as the interstate water dispute is concerned, the Parliament has the power to constitute an interstate water dispute tribunal. The Parliament can constitute tribunals, and the tribunal verdict if the parliament, if the sender notifies, if the union government notifies in the gazette, it is binding on the states. So, the interstate water dispute tribunal awards, award means the tribunal verdict, the awards if notified by the center, it is binding on the states. It is binding on the states. It is binding on the states. Meaning the states have no choice other than following that, implementing that award. Again, if the states are not following it, 356 will be there, they will be dismissed. So, that is the challenge. So, parliament has the power to constitute interstate water dispute tribunals, and awards if notified in the gazette. We will be seeing that separately in the cooperative federalism, but that is the provision. Again, for the coordination between the states, the president is empowered under article 263 at 10th point, under article 263, under article 263, the president can constitute councils to resolve the disputes or discuss subjects of common interest. Interstate councils can be created. Interstate councils. Again, it's not that the council is binding or anything, the states have no role. I mean, I have just mentioned it, we will be talking about this council separately under article 263.